You had an interesting story this week that we're going to be talking about here. The state of New York, in a court filing, made an interesting argument for why its new post-Bruin concealed carry law should be upheld. If you want to tell us a little bit more about what they put in that court filing.
Yeah, so this relates to New York's good moral character clause, which allows officials to deny applicants based on subjective concerns about their moral character, right? You could perhaps see why that might be problematic to some people, but it's being challenged in court by Gun Owners of America is the main gun group behind this one. But yeah, New York filed a brief which defended this clause by citing historical bans on the ownership of guns by Native Americans and Catholics. They said that was relevantly similar to their good moral character clause. And the reasoning they used is that those bans were against people considered to be dangerous or disloyal to either the United States or England, because these laws a lot of them are actually from the 17th century, not from the founding era, although obviously some of the Native American bans did continue on into the early days of the American Republic. But the idea is that these were supposed to be examples of general bans against dangerous people owning guns, and so therefore New York can subjectively ban people from carrying guns based on, or I suppose they also have pistol purchase permits there,
right,
from owning them if they're considered to be suspect or dangerous, potentially dangerous. And so, obviously that caused a bit of a stir because, well, New York is saying that their modern regulation is relevantly similar to these racist, bigoted gun bans of the past. And that didn't impress a lot of people. And so it'll be interesting to see what the court does with this argument.
No, I think that's right. And just for context, for people who I'm sure many of our listeners do know, but they didn't just pull this out of nowhere. This is the court attempting to use the new Bruin test that was established by the Supreme Court, which said that no longer can you justify gun regulations on an interest balancing scale, where is it working towards the goal of improving public safety. The court said, no, you can't do that. You have to decide, does the law implicate the text of the Second Amendment? And if it does, is there a sufficient historical analog to this law that would allow us to uphold it under the Second Amendment? So this is them, as you said, trying to find a relevant historical analog. But as you also pointed out, I'm not sure that drawing on laws that are explicitly racist is going to buy them much favor with the courts.
Yeah, I did a members piece that looked at or that asked a bunch of experts what they thought about this. And I asked, four or five different constitutional law experts from different sides of the aisle. We had Robert Leiter from George Mason University, Andrew Winkler from UCLA, Eric Rubin from SMU, Andrew Willinger from Duke, and Josh Blackman from Southern Texas, who also, basically they didn't think this was going to actually work in court. Like you said, they noted that this is an outgrowth of Bruin. This is New York trying to respond to Bruin, trying to come up with historical analogs for their laws. And I think as Leiter put it, they just don't have many to point to. And so they're using this, this argument about these racist and bigoted gun bans being an example of depriving dangerous people their gun rights. that argument has been around. Even Justice Amy Coney Barrett made this argument or at least cited it in Cantor, which was about nonviolent felons. She used it to try and say that that nonviolent felons, shouldn't be prohibited from owning guns because only dangerous people should. And she used this example to explain why dangerous people considered to be dangerous were that's a historical tradition of denying them gun rights. But I mean, it's not a very solid foundation.
Right.
If that's your argument, at least from my perspective. But taking that argument and then trying to apply it to this subjective denial of rights to anyone basically considered for any reason to be, or for many different reasons to be a threat. I mean, Leiter talks about New York City at one point was trying to deny permits to people who had too many speeding tickets, too many traffic violations. So really not. He doesn't think that it's a close connection, and none of these experts seem to think that this was going to be a winning argument in court. Although they did think that perhaps this law or some other subjective discretionary standard for permit issuing might survive based on other factors like, there are some of these discretionary rules in some shall issue states that, go back a little bit further and the court didn't find issue with in Bruin directly, although obviously the court wasn't specifically deciding that issue in Bruin. So it's hard. I don't know how much the court is going to allow discretionary subjective standards to remain in the gun carry permit application process, because they seem pretty adamant that they don't want this right can't be limited by subjective judgments.
Yeah, no, and that's what I think is interesting about this particular argument, because as you pointed out, there are other states with similar clauses, some of them are almost identical to this good moral character requirement. I know Massachusetts kept theirs in their carry permit law. I believe California still has one in their relevant statute, and they're also working on their own sort of omnibus restricted post-Bruin carry bill. And you can believe that gun rights advocates are going to challenge those laws as well at some point. And
sure,
it'll be interesting to see if governments in those states take up this same line of argument when they're trying to look for historical analogs to uphold that, because they're going to fight to defend those requirements.
I think that if your only historical analog are these explicitly racist or bigoted gun bans, then maybe your law is not that great to begin with. I don't know. Like, you'd think you could find other. Now, to be fair, New York did pull out a couple of other arguments. That's what makes this even more bizarre to me personally. I'm not a constitutional law expert like some of these people that we talked to for that members piece, but New York pulled out a couple of other perhaps also perilous arguments, but they pointed to some militia laws that let people be disarmed if they're allowed, officials to disarm people if they suspected the person was disloyal to the United States, or they specifically cited Shays Rebellion and how people who participated in Shays Rebellion, which again was an active rebellion against the government, they weren't allowed to have their arms. They had their firearms taken away for 3 years until they swore an oath of allegiance. And a lot of these things resulted in like swearing an oath of allegiance or paying a very small fine, which is also obviously pretty different from what New York's law does, which is just deny people their rights indefinitely without any recourse. But either way, like, they found some other analog they could at least point to, and I don't know why they didn't just go with that one. Probably, I guess, because Barrett had mentioned this particular line of reasoning at one point in her dissent. But boy, it's just not a super compelling one, I don't think.
No, yeah, and there's no reading between the lines with this. These are as you point out, these are laws that are overtly racist. They in explicit terms identify disfavored ethnic groups to disarm. So it's not like one of these things where it's like, oh, it had disproportionate effects on certain groups. No, these were overtly targeted at certain groups. So it's, yeah, as you said, it's kind of a bold strategy to cite that favorably to uphold your law.
And, a lot these modern regulations that New York has in place, including the good moral character clause, which, again, it's not hard to see how that can be used by a bigoted official to discriminate against people. And frankly, as we saw with some of the briefs in Bruin from public defenders in New York, these laws are generally used in the modern day in a manner that's fairly discriminatory. It's applied mostly to young black men. They're the people who are being prosecuted under these laws for the most part, much more disproportionately compared to their population, right? Their percentage of the population. And so while these modern laws aren't explicitly about barring black people or Native Americans or Catholics from owning guns, they do have discriminatory effects, or at least effects that are applied disproportionately to certain racial groups. So, it's an especially bad look to go and take a law that has been criticized for its disparate impacts on different minority groups and then justify its existence by pointing to explicitly racist laws from the past. Yeah,
that's a good point.
It's pretty remarkable. It'd be kind of like if you tried to justify some of the, like a voter ID law by pointing to, poll taxes and, the grandfather clauses and things of that nature from the past as well. Like, even though the modern law, if you're going to do that, people are going to be a lot more suspicious about your modern iteration of that voting restriction. So, it's fairly remarkable to see them do this. I think, you've heard forever, if you've ever been on the internet and interacted with a gun rights advocate, you've heard that gun laws are racist, right? That in fact, the argument you'll commonly hear is that all gun laws are racist. And this formulation, now you have New York saying this in court. That, our laws are similar to these racist laws from the past. And it's not something I expected them to ever do. Even with Bruin, I understand, the experts kept saying, well, this is because of Bruin, because Bruin makes you look for historical analogs. Well, I get that, but you don't have to cite the racist ones, the openly, extremely, explicitly racist ones. You could, like I said, they found some other things to point to. I don't know that they're better arguments, but they at least don't have you saying, our law's like this racist law. So,
it'll be interesting to see how long-lived this line of argument goes in these future court cases, because that's a tough look.
Yeah, I mean, even the left-leaning experts didn't think this was going to actually catch on and be effective in court. And regardless of what Barrett might have written in a dissent at one point, I don't see the court adopting this line of reasoning anytime soon. It's also just like they want to take this thing and then apply it extremely broadly anyway. Like, their lesson that we're supposed to take from these laws is that anybody the government deems dangerous for basically any reason, in this case, because the people passing these laws were bigoted against Native Americans and Catholics. Therefore the government can declare anybody suspect or dangerous without them having to actually commit any sort of crime, right? Which is something I think we've rejected quite a long time ago in this country, at least the explicit version of it, right? So we'll see what happens with this. We'll continue to follow this case